Welcome to New York Law School. How's everyone doing today? Great. Or as we like to say, we are New York's Law School. I'm Anthony Crowell, the Dean and President here, and we are honored you are here with us for an historic and auspicious moment as we host United States Supreme Court Associate Justice Ruth Bader Ginsburg. We are honored to host so many distinguished guests, including from our state and federal judiciaries, our Board of Trustees, and our wonderful faculty. And I also want to just offer a very special thank you to our extraordinary team here at the Law School who's worked tirelessly with Sidney Shainwald to put this extraordinary event together. So thank you. The Shainwald Lecture is always a magnificent event, and each one of them has featured a momentous national leader, including Supreme Court Justices Sandra Day O'Connor and Stephen Breyer, House Minority Leader Nancy Pelosi, former Senators and Cabinet Secretaries John Kerry and Chuck Hagel, the late Senator Ted Kennedy, and most recently, former Senate Majority Leader George Mitchell. The series provides a unique forum for thoughtful and intellectual discussion featuring the most prominent leaders in public and judicial service. It was founded by our very own Sidney Shainwald. Sybil? She is an alumna and a member of our Board of Trustees, and the lecture series was established in honor of her late husband, Sidney, who led an incredibly dynamic life as a highly successful accountant, but also a highly successful consumer advocate. Sybil herself is a 1976 graduate of New York Law School. She attended law school as an evening student after a successful career in consumer advocacy. Armed with her degree, she became one of the foremost legal pioneers in the world, a visionary who has made fighting for women's health her unrelenting mission for the last 3 decades. Her impact and legacy can be seen everywhere, from New York to Bangladesh. Just last November, we honored Sybil, as well as our wonderful Professor Nadine Strossen here, as 2 of our groundbreaking women, a term that is one of the words we can describe our special guest, Justice Ginsburg, today. Justice Ginsburg is, of course, a giant in our profession, and she has transcended into a singular cultural icon. Now, I say that because a student recently asked me why we refer to her as that, and I pointed to something that my predecessor here at the law school left me. It was a coaster with Justice Ginsburg's image on it. And then Sybil, as any good dean would do when a member of the Board of Trustees provides wardrobe, she gave me socks with Justice Ginsburg's image on them in a very public way, and I'm required to wear them, but proudly and happily wear them today nonetheless. So, beyond that, I'm going to leave comments about her extraordinary body of work as an attorney and jurist to Chief Judge Robert Katzman of the U.S. Court of Appeals for the Second Circuit and Ken Feinberg, both of whom hold honorary degrees from New York Law School, Ken from 2012 and Judge Katzman from 2016. I will say, though, as a law dean who works every day with aspiring lawyers, I've never seen someone have quite the effect that Justice Ginsburg has had on our students. If you walk through this building today, you will see our auditorium filled to the max, classrooms filled to the max. The level of participation among our student body is truly extraordinary. I couldn't be more proud. I do think there's a wide range of reasons why, but the essence is that she is compelling. She came into the profession at a time where there were few women and overcame every obstacle in her path to reach the heights she has. At NYLS, we're proud that our student body today is 60% women. It's a truly incredible feat. Her career and her life convey a message that we like to convey to all of our students. She's embodied a fearlessness, a relentlessness, and unmatched grit at every step. Grit is a trait shared by many of our students, and all of us here work hard to ensure our students have it to help fuel them as they move into their careers. Having grit helps overcome so much, and many of our students have persevered through huge challenges to make it through our doors, and Justice Ginsburg's example has been a unique source of inspiration to them. When she arrived today, we greeted her with several of our student leaders. Many are in the room with us. And I can't express the joy and excitement that was on their face. It was something I won't forget. Her accomplishments and legacy don't just rest on historic judicial impact, but they live in the thousands of young people like these students who look up to her as their role model of what a leader in our profession and society should be. And I'm especially excited for her talk today, as we get two historic figures for the price of one, with New York Law School's John Marshall Harlan II professor, Nadine Strossen, leading the conversation. I now turn it over to the person who made today possible, Sidney Shainwald, to say a few words of welcome.
Welcome, everyone. I am so pleased that you are all here, and I am so pleased with our guest of honor, who couldn't be better than Justice Ruth Bader Ginsburg. Couldn't have done more for society, civilization, and the judicial system. Thank you, Dean Crowell, for your extremely kind introduction, and welcome to the 10th lecture in honor of my remarkable partner, Sidney Shainwald, who was extremely supportive of my going to New York Law School 4 nights a week for 4 years. He believed in the Equal Rights Amendment, gave money to NYLS before I did. And nobody would have enjoyed listening more to Justice Ginsburg and Judge Katzmann, Ken Feinberg, all of whom represent Sidney's ideals of social and economic justice, and all of whom are working to attain those goals. This audience is filled with people who represent Sidney's values in so many different areas, people who care about the world and who work to make it a better place. He would have enjoyed talking politics, especially at this time. I'll just, I will not take up time with this program, although I could say a lot about my wonderful husband, and he would be most proud to be here today. Sidney paid tribute to the founding president of Consumers Union and spoke on behalf of his staff for Consumers Union on the occasion of Dr. Colston Warren's retirement. Jim Guest is here from Consumers Union somewhere. And anyway, this is what Sidney said about Colston Warren. A unique model, a once-in-a-lifetime production, exceedingly efficient, definitely top-rated, and the best buy ever. The same can be said for Sidney Shainwald. It is an honor to introduce Kenneth Feinberg. Get your, I don't think I have your introduction.
Go ahead, it's all right.
No, it's all right. Kenneth Feinberg is the come back. He needs no introduction, it's true. But he's the nation's leading expert in mediation and alternative dispute resolution. He has administered numerous high-profile compensation programs, having served as special master, as you all know, of the September 11th Victims' Compensation Fund. In this capacity, Mr. Feinberg developed and promulgated the regulations governing the fund's administration, oversaw the evaluation of applications, determination of appropriate compensation, and dissemination of awards totaling over $7 billion. Come back. Ken is now serving as Special Master of the U.S. Victims State-Sponsored Terrorism Fund being administered by the Department of Justice. Among the numerous funds and compensation plans, Ken has served in a pro bono capacity, an administrator in the past, the Sandy Hook Victims Compensation, the Aurora Victim Relief Fund following the Colorado movie theater shooting in 2012, the One Fund Boston Victim Relief Fund arising out of the Boston Marathon bombings, where 3 people were killed and several hundred people were injured, the One Orlando Fund for the victims of the Pulse nightclub shooting. In 2010, the Obama administration appointed Ken to serve as administrator of the Gulf Coast Claims Facility to compensate victims of the BP Deepwater Horizon oil spill in the Gulf of Mexico. Secretary of the Treasury, Timothy Geithner, appointed Ken in 2009 to serve as Special Master of the TARP, Troubled Asset Relief Program, in order to determine the compensation structure of employees of corporate TARP recipients who had received exceptional financial assistance. Ken was also appointed Special Master for Victims of DES by Judge Dacby Barnstein, who is here today. And Ken was designated Lawyer of the Year by the National Law Journal. I think he's Lawyer of the Century, but he is listed in Profiles in Power, the 100 most influential lawyers in America. He is the author of numerous articles and essays on mediation, mass torts, and other matters. He received his JD from New York University, where he was articles editor of the Law Review. He was a law clerk for Judge Stanley Fold, New York State Court of Appeals from, I guess, 1970 to 72. At any rate, he became a partner at K. Schuler, Bierman, Hayes, and Handler from 1980 to 1993, and founded the law offices of Kenneth R. Feinberg shortly thereafter. Ken Feinberg is the nation's most renowned mediator, an extraordinary man, a fabulous friend. It is my honor and my privilege to introduce him.
I want to thank Sybil for that 22-minute introduction. I can't wait to hear what I'm going to say after that. This is just the latest example, as you know, of what Sybil does. If there's any lawyer in the United States who understands the call to service and the requirement that lawyers give back to the country, it's Sidney Shainwald, and grateful. I also, at the risk of, I could mention 100 people in this room, but I must mention my colleague Camille Byros, who's sitting right here, who right now is trying to resolve hundreds of church abuse cases in the state of New York. And the fact that my colleague is here today means that the Feinberg law firm basically is closed today. I mean, it's a holiday, I guess. But I also want to pick up on just one point Sybil said. You cannot imagine the importance and the impact of American law over the last 50 years or more that Jack Weinstein of the Eastern District has had in this country. I simply have to introduce two people. First, the Chief Judge of the Second Circuit Court of Appeals, Judge Katzmann, appointed Appointed as a judge in the Second Circuit 1999, Chief Judge 2013. I can tell you, because he won't, the steps he's taken as Chief Judge, creative, bold outreach to the consumers of justice in this country, the American people and others, and the fact that he's here today to participate signals, I think, is an important milestone, and we thank the Chief Judge for his incredible service to the nation. And finally, I want to introduce our interviewer, Professor Strossen, here at the law school, New York Law School, one of the law school's own, and also is a very, very important former head of the American Civil Liberties Union, who I can tell you, during her tenure, really brought the American Civil Liberties Union into the forefront, modern American law in this country. She played a tremendous role in that, and we're grateful that Professor Strossen has agreed to interview Justice Ginsburg today. Now, before I turn it over to Professor Strossen, who's going to ask questions of Justice Ginsburg and then take questions, there's one question that when it's time for the audience to ask questions, we don't have a lot of time, do not ask the following question of Justice Ginsburg, because I'll preempt it, so everybody will know, and then we can go on to other questions about federal preemption and federal law and all that. Do not ask her how long she plans to serve on the bench. She has told me, so we'll preempt it, that she plans to serve at least another 20 years. So there we are. And with that, I am done, and my job now is introduce the distinguished Chief Judge, Judge Bob Katzman.
Ken Feinberg, thank you so much for your very kind words and for your many tireless contributions to the public good. And I also want to thank Dean Crowell, Sidney Shainwald. It is an honor to be part of this lecture and to offer a few words about Justice Ginsburg. I have the great privilege and pleasure of calling Justice Ginsburg a close friend. And indeed, I have thought of her and her beloved husband, Marty, as family members. We met in the 1980s when I was in Washington, D.C., working at the Brookings Institution and then at Georgetown, where Marty taught as well. I was witness to her confirmation journey nearly 25 years ago when Senator Moynihan, her Senate sponsor, asked that I be of assistance as her nomination weaved its way through the Senate. To say that I was not needed is an understatement. How do you introduce someone who needs no introduction? How to introduce someone who's so famous she's known just by her initials? Who has, perhaps most surprisingly to her, attained world celebrity. She is the subject of a new documentary, a feature film starring Felicity Jones and Armie Hammer. She is the subject of an opera. Her face, as Dean Crowell has said, appears on T-shirts, mugs, tote bags. You can learn how she works out in a new exercise book written by her trainer. You may have seen the Politico story by the reporter who said, Ruth Bader Ginsburg's workout routine nearly killed me. That Ruth Bader Ginsburg has been a path-marking legal mind as a litigating architect of gender equality, we know. That she has been and is a jurist of extraordinary distinction who has left such an indelible mark on the law, we know. That the world is a better place because of her, we honor and cheer, and that we all know. What more then can be said about this brilliant, compassionate judge, appreciator of music, art, the world, who is really a living legend, and I think we would all say deservedly so. I offer some personal some glimpses into the life of this Renaissance human. First, this observation. Ruth Bader Ginsburg's concern about the world around her began early. As a 13-year-old, in a bulletin published by the East Midwood Jewish Center, a year after the end of World War II, she wrote, and this can be found in her book, My Own Words, and I quote, this is a 13-year-old, "We must never forget the horrors which our brethren were subjected to in Bergen-Belsen and other Nazi concentration camps. Then, too, we must try hard to understand that for righteous people, hate and prejudice are neither good occupations nor fit companions." This is a 13-year-old. "We cannot feel safer until every nation, regardless of weapons or power, will meet together in good faith the people worthy of mutual association. There can be a happy world, and there will be once again, when men create a strong bond towards one another, a bond unbreakable by a studied prejudice or a passing circumstance." As she grieved the loss of life in Bergen-Belsen, 13-year-old Ruth Bader could not have known that one casualty of that concentration camp just a year earlier was a young girl, also a writer, just 4 years older than the young Ruth. Anne Frank, too, wrote about the human condition and yearned for a happier world. Some years ago, I sent Justice Ginsburg a new edition of the Diary of Anne Frank because I had read a passage in the diary in which Anne Frank pondered why women were thought inferior to men. I have imagined that had Anne Frank survived, that somehow she and Ruth Bader Ginsburg would have met in the course of their lives and become friends and then work together on the world stage. These minds that grappled with humanity and justice, minds that loved art too. Another observation. Justice Ginsburg's influence as a writer, always a reader and a writer, sensitive to words and rhythm and style. She says herself that her writing bears the traces of one of her college professors, Vladimir Nabokov. Yes, that Vladimir Nabokov. Her words and phrasing have a clarity and an elegance and a rhythm. The next time you read a Ginsburg opinion, I urge you to read her sentences aloud, and you will understand what I mean. Her writings are truly guides for the rest of us in the trenches. Her book recommendations. Justice Ginsburg's life's canvas is wide-ranging. Take, for example, the book she reads. With wide-ranging interests, she might recommend any number of books. For example, Donna Leon's novels. The mysteries take place in Venice with detailed descriptions not just of the city, but of the food. Marty, as she will tell you, first told her about those mysteries. One of her proudest moments, when she performed as she did not long ago at the Washington Opera, or perhaps when Placido Domingo serenaded her at a Harvard degree ceremony. A friend for all seasons. Ruth Bader Ginsburg is a person with a happy, thriving family and a close network of friends, colleagues, and former clerks. When a friend is in the hospital during the holiday season, confronting serious health issues, this Supreme Court Justice checks in daily with indispensable support and guidance, giving hope, inspiration, and cheer. How she does all that she does, she really must have superhuman powers to be able to do so much in the course of a day. Determination and perseverance. When she missed her high school graduation because her mother, a role model and hardworking bookkeeper, had just passed away, the young Ruth carried with her that searing loss and also had the resolve to continue on with discipline, looking forward, tackling challenging work at college, at Cornell, where few women were. It was a perseverance that would mark her approach to life Still so young and grounded in conscientiousness and honesty, she had good fortune and judgment. And with that judgment and good fortune, she met and then married the very brilliant, very confident Martin Ginsburg, who I think, by the way, would say that she also had the good judgment to marry him. The incomparable Marty. Taking a break from a conference in Madrid not long ago, visiting Gaudi's unfinished cathedral, Sagrada Familia, which he had not seen in some 20 years, when observing the display that depicted the innovative structural engineering behind the cathedral, Justice Ginsburg remembered, Marty was fascinated by that. As a judge, as we all know, Justice Ginsburg has left her mark and continues to do so with her extraordinary opinions and dissents that bear her signature. And in so doing, she has expressed the fairness that is America's promise. She is a jurist who never takes a cheap shot, who understands that the opposing sides have their views as well. Even as she might dismantle the arguments of the opposing side or sides, she does so respectfully and civilly. How to understand a capacious, organized brain that knows the Constitution, that knows the law, that's methodical and also attentive to nuance and style, that has such a keen understanding of the noble aspirations of this country, keeping in mind the rights of the individuals, especially the most vulnerable in society. Perhaps sometimes there's no fully accounting for greatness. It's here, and we do well when we recognize it and know it and honor it. I speak for everyone here when I say, welcome, Justice Ginsburg. We are so happy that you're here, and we can't wait to hear what you have to say.
Thank you so much for those wonderful introductory remarks. And now to the main course after delightful appetizers. Justice Ginsburg, it is so generous of you to spend your precious time and share your wisdom with us. And I really appreciate the fact that you are so open. You have instructed everybody who's interviewed you to ask you anything with no pre-clearance, subject to the Ginsburg rule, which means we may not ask about any issue that is before the Supreme Court or is likely to come before the Supreme Court. So I will try to honor that, but I do remember Alexis de Tocqueville warning that in America, just about every issue may end up before the Supreme Court. So you will exercise your right to cut me off if I tread on inappropriate ground. So I also wanted to tell you, Justice Ginsburg, that I solicited questions from students and other members of the New York Law School community. So I'm going to be asking you a mix of questions from myself and questions from other people. I wanted to start, though, with the ACLU, because that is what first brought me in contact with you when I was a student, and I love the fact that I can empathize with the students in the overflow audience and here, because I heard you when I was a beginning student at Harvard Law School, and you were absolutely inspiring to me and really made me think seriously of the ACLU as a wonderful place to do work, not only for women's rights, but for human rights more broadly. I'd love it if you could comment on why you chose the ACLU and how it fit with your concept of women's rights and gender equality.
Let's go back to the late 60s, early 70s. It was apparent to me that the Supreme Court would soon catch up with the change in the way people were living their lives. And I thought about what group I might affiliate with. And I thought about the National Organization for Women and Women's Equity Action League. And then it came to me that if women's rights are to be high on the human rights agenda, men had to be part of the operation too. And the ACLU being the foremost protective of civil liberties organization in the United States seemed the right place to be. I will say that early on there were some misgivings among many ACLU supporters. They thought that the ACLU had a client. That client was the First Amendment, and that a shoemaker should stick to his last. But although the ACLU came to the women's rights advocacy somewhat reluctantly, once they got there, they were at it full steam. And I think, Nadine, you're too young to remember some people who were instrumental in bringing the ACLU there. One was Dorothy Kenyon.
Yes. I never met her, but she's a legend.
And her mission was to put women on juries in every state in the United States. You know, students today, when they hear that it wasn't so long ago that this very state, New York, had an exemption from jury service for any woman. That was Dorothy Kenyon. The other was Pauli Murray,
She's amazing.
who was on the ACLU's Equality Committee, and had written an article in the 1960s that impressed me strongly. It was called Jane Crow
Yeah.
and the Law, and she traced the many ways in which the law differentiated on the basis of gender, and explained how those laws were not, as was once thought, favors to women. Well, that's a long answer to why.
No, but
I
yeah,
became
it's a very,
affiliated.
very fascinating, and there are a lot of threads to pick up on, but one that I would like to follow is you're so famous for having always advocated gender equality for men as well as women and representing men. I believe for reasons of principle, but also for reasons of strategy. Could you comment on that? And then why the name Women's Rights Project? Or maybe you were not part of the naming process.
The overall goal of the project was to advance the welfare of girls and women, so that the half of society that had been subordinate would be able to contribute and do whatever their talent allowed them to do.
Absolutely. And I want to ask also in terms of, you made this comment about the ACLU thinking that the First Amendment was the only client. You were not only the founding director of the Women's Rights Project, but what is somewhat less well known, you were a member of the ACLU's National Board of Directors and a general counsel at a time when the ACLU had its own glass ceilings, right? There were relatively few women in those positions of organizational leadership. I remember when you were nominated for the Supreme Court, Marty called me and we had to help him produce every single minute of every single board meeting that you had ever attended and every issue you had ever debated.
Let me tell you something about that. My White House handlers were a little concerned about my ACLU connection. And they knew that the committee had asked for all those materials. And so they would quiz me. You were on the ACLU board in 1976. That year they passed this or that resolution. How did you vote? And my response was, forget it. There is nothing you can do that would lead me to speak of the ACLU in any but the most praiseworthy terms. Well, as it turned out, This is in 1993, July 1993. Not a single question was asked at the hearings about my ACLU.
Yeah, I was going to ask you about that. It was very surprising. Obviously, you had been prepared for that, and just a few years earlier, Michael Dukakis, for the young people in the audience, the Democratic nominee for president, was attacked by George Bush Sr. as being a card-carrying member of the ACLU. So it was not the most popular organization in many quarters. And I looked up, I remembered that Calvin Trillin had written this amazing ditty in The Nation on the nomination of Ruth Bader Ginsburg. I'm only going to read a few lines. Somehow, all the White House vetters remained unmoved by those 4 letters that spooked Dukakis through and through the dread quartet ACLU. The paths in women's law she plowed were plowed while working for this crowd. Republicans don't seem annoyed to hear the judge was thus employed. They cheer she made some law impartial and got compared to Thurgood Marshall. So what do you think had changed? I mean, why was that the case? It's a compound question. And would that happen today with somebody with your background, with an advocacy organization such as the ACLU, be confirmed 96-3, be confirmed at all, be nominated at all?
And Nadine, I will answer that question, but may I go back to the,
yes,
to the
you may.
comment you made before about that in a number of the cases that the ACLU brought in the 70s, the plaintiffs were men.
Yeah, sure.
The person disadvantaged was always the woman. So they were all about how society treated women. So to take one of my favorite cases, Stephen Weisenfeld's case, this was a man who was married to a high school math teacher. She had a healthy pregnancy. She taught into the 9th month. They went to the hospital, and the obstetrician came out and said, "You have a healthy baby boy, but your wife died of an embolism." And Stephen Weisenfeld vowed that he would not work full-time until his child was in school full-time. And he figured out that between Social Security benefits plus what he could earn up to the ceiling, he could just about make it. So he went to the Social Security office and applied for what were called child in care benefits. He was told, "We're very sorry, but these are mothers' benefits. They're not available to fathers." He then wrote a letter to the editor, to his local Edison, New Jersey newspaper. And it went like this: "I've been hearing so much about women's lib. Let me tell you my story." And then the tagline was, "Does Gloria Steinem know about this?"
Yeah.
It was suggested to him that he called the New Jersey affiliate of the ACLU, and that's when his case began. When it got to the Supreme Court,
And how did you get involved with it, Justice Ginsburg?
a friend who was on the Rutgers faculty in the Spanish department lived in New Jersey, read the letter, called me, and I suggested to her that she have Stephen call the New Jersey affiliate. So in those days, you could go to a 3-judge federal district court and then right to the Supreme Court with no intermediate appellate court in between. So I was up to the Supreme Court's decision, unanimous judgment, reasoning divided 3 ways.
Yeah.
Justice Brennan led the group that said, of course, the discrimination begins with the woman. She pays the same Social Security taxes as the man, but her taxes don't get for her family the same benefits as a male wage earner family would get. And then there were a few who thought, this is discrimination against men as parents. If women are widowed, they have the choice to take personal care of their infant. But men don't have that choice. They must work and provide a substitute for themselves at home. And then one, who later became my chief, he was then Justice Rehnquist, said, this is totally arbitrary from the point of view of the baby. Why should the child have the opportunity for care from a sole surviving parent if that parent is female, but not if the surviving parent is male? So that case illustrates how gender-based lines in the law hurt everyone. They hurt women, they hurt men, and children.
And you make that point brilliantly, and I was just being devil's advocate and suggesting, well, maybe it should even be called the Human Rights Project.
But let's go back to
the ACLU and the non-issue.
Let me start with the 80s, when my good friend Justice Scalia was nominated. It was well known what his views were. He had been a law professor, done a lot of speaking and writing, and he had been my buddy on the D.C. Circuit. The vote was unanimous to confirm him. 1993, despite my ACLU connection, the vote to confirm me was 96-3.
May I tell people who those three naysayers were? The only vote, and this is from Linda Greenhouse's New York Times article at the time, the only votes against her came from three conservative Republicans, Jesse Helms of North Carolina, Don Nichols of Oklahoma, and Robert C. Smith of New Hampshire. There was one Democratic senator who was absent from the vote. Senator Helms contended that she supports the right to abortion unreservedly and, this is 1993, is likely to uphold the homosexual agenda.
And let me say, Jesse Helms was extremely helpful in this respect. My colleague on the D.C. Circuit, David Santel, had been Jesse Helms' advance man for a number of years. And David came into my chambers at the D.C. Circuit. He gave me a big bear hug, and he said, Ruth, Jesse's not going to vote for you. I said, heaven forfend it. And he said, but he won't hold you up, because any senator could have put a hold on me, and that would have carried the nomination over until the fall. But I had the luxury of coming on board. I was confirmed August 3rd, so I could prepare fully for that first Monday in October.
Great. Well,
but just think, it was the same for Justice Breyer. His vote was in the 90s. For the last 4 nominees, it hasn't been that way.
Yeah.
The vote divided on party lines, and this is a plague on both your houses, because that was true not just of Elena Kagan and Sonia Sotomayor, but also my current chief, Chief Justice Roberts, and Justice Alito. And my hope is that we will one day get back to the way it was and the way it should be.
Do you have any advice for how that could happen?
I think Chief Judge Katzman arranged what I think was a very good beginning. There's an opera called Scalia
Yes,
Ginsburg.
yes.
And he decided it would be a good idea if the members of the House and Senate Judiciary Committee and their staffs were invited to hear excerpts from Scalia Ginsburg. I think it may have been effective. At least Senator Grassley asked to have a copy of my remarks the next day. I think it will happen, and I expect to live to see it.
And it ties into, I mean, your friendship with Justice Scalia, whom you famously called your best buddy on the court. But you've also, so that obviously bridged some ideological differences, but you've also talked about the Supreme Court as the most collegial place you've ever worked, and that remains true despite the partisan breakdowns in the appointment process. You've actually said it was an even more collegial place to work than the ACLU, than Columbia Law School, like Rutgers Law School. So seriously, can you give some tips from that experience, how the Supreme Court as an institution is able to work so collegially and even have personal friendships across divides that seem unbridgeable, not only in Congress, but on so many college campuses and in our community at large?
We know that the institution can't work well for the people of the United States if we don't respect, and in most cases genuinely like each other. We begin every conference and every sitting day by going around the room. Each justice shakes hands with every other. That's to say, you circulated a nasty dissent yesterday, but we're all in this together. So, to use one of Justice Scalia's favorite expressions, get over it. The Supreme Court is small in a town that's puffed up with bureaucracy. Our operation is only the 9 justices, 4 law clerks, 2 judicial assistants, 1 chamber's aide, and that's it. I can tell you why I regard my colleagues in some way as family. During my tenure, I have had 2 bouts with cancer. And both times, my colleagues rallied around me and made it possible to get through those trying times without missing a day in court. Justice O'Connor's advice: Ruth, you're going to have chemotherapy. Set it up for Friday. That way you'll get over it by Monday. And don't even think about answering all the letters and the calls from well-wishers that you will receive. Justice Souter said, anything that I can do, Ruth, anything at all, just call me. So I called him one day and said, I'm at Washington Hospital Center, and I just finished with my chemotherapy. And Marty, my husband, called and said, when you're through at the cancer center, come see me in the heart wing. He was having a heart procedure. We had tickets the next night to the Washington National Opera. So I called Justice Souter and said, you told me that if it was anything at all that I would like, just call you. I'm calling to ask if you will come with me to the opera tomorrow night because I don't want to sit next to an empty seat.
Oh.
And Justice Souter, who is the only person I know who works even harder than I do, came to the Washington Opera. People were astonished because he had received so many invitations, and he'd always said, Sorry. I think the only time he'd been there was when they had a preview of a film about Thurgood Marshall.
Oh. So,
And then the chief, I can't tell you which opinions these were, but he said, Ruth, I'm going to keep your assignment light. And I said, not yet. This is when I'd done the surgery and hadn't yet started the chemotherapy and radiation. I said, Chief, not now. Now I feel good. But when I'm going through radiation. So he said, all right. Which case would you like? It never happened before, and it never happened again. So when I told him, he said, oh, I was going to take that one for myself. But he gave it to me.
I mean, what you're describing, obviously, is getting to know people as individuals and not putting them in ideological boxes. And unfortunately, from what we read statistically and anecdotally, there are a lot of people who don't even want to meet somebody of a different political party and so forth. You have often commented in the same vein, both on a personal and an institutional basis, about how anger is such an unconstructive emotion. And I think about you all the time. In fact, I've heard those lines from you quoted a lot because we're living in an era of outrage. And it's often righteous outrage that is justified by explosion against injustices that have been committed, such as sexual harassment or racial discrimination in the criminal justice system. But could you comment about a constructive way to be passionately engaged in combating injustice, but how anger might not necessarily effectively advance that cause?
I'll give you the example of a young woman named Shanna Kniznik. She was a second-year student at NYU Law School when the court handed down its decision in the Shelby County case, which declared the most important provision of the Voting Rights Act of 1965 unconstitutional, despite that act having been renewed periodically with overwhelming majorities on both sides. And so Shanna was angry, but then she thought, that's not constructive. What can I do that would be positive? And what she did was to start a Tumblr with my dissenting opinion in the Shelby County case. And then it took off from there into the wild blue yonder. I mean, it's amazing. I am soon to be 85, and everyone wants to take their picture with me.
And this was the beginning of the notorious RBG movement. And I mean, it's just unbelievable. You've often said that if you had your fantasy job, you would be an opera diva. Instead, you've had to settle for having an opera written about you and being a social media rock star. So, not to mention the star of a film. And for those of you who read the coverage about Sundance, where Justice Ginsburg talked with Nina Totenberg, all the buzz was that you were the biggest celebrity there. And I also heard you said that Robert Redford really is good looking. Now, and I have to tell you something, of all the different accolades that have been paid to you, I will tell you that one of my former RAs and her best friend are having your initials tattooed on their...
Oh, no. That's the one thing that I don't like.
They didn't tell me which body part. I did not inquire. But I think it's so interesting. I saw a theme of, I love to celebrate law students and the potential power that they have. So the fact that the second-year law student started the whole notorious RBG movement. You've already mentioned the opera. That was actually written by, the Scalia-Ginsburg opera was written by another law student, right?
Yes, it was a young man, a musician. he had degrees in music from Harvard and Yale, and then decided that it might be good to know a little about the law. So he enrolled in his local law school, which was the University of Maryland. He takes a constitutional law course, and he comes upon these dueling opinions. Scalia for the court, Ginsburg in dissent, Ginsburg for the court, Scalia in dissent, and decides that this could make a very funny opera. The opera is roughly based on the plot of The Magic Flute. Scalia is locked in a dark room being punished for excessive dissenting. I then enter through a glass ceiling to help him get through the test that he must pass in order to be released from the dark room. Then a character who's left over from Don Giovanni, in Scalia Ginsburg, he's called the commentatore. He said, "Why would you want to help him? He's your enemy." And I say, "He's not my enemy. He's my good friend." And then we sing a duet. We are different. Different in our interpretation of legal texts, but one in our reverence for the Constitution and for the institution we serve. Before that closing duet, the two of us are introduced to the audience, Scalia by singing a very Handelian rage aria, which goes like this. The justices are blind. How could they possibly spout this? The Constitution says absolutely nothing about this. And then I answer him, you are searching for bright line solutions to problems that don't have easy answers. But the great thing about our Constitution is that, like our society, it can evolve. Yeah. And then the lyric soprano breaks into a jazz routine, let it grow, let it grow.
That's wonderful. The other, I thought I knew a lot about you. I had read everything you've written, and dissents and majority alike, and read a lot about you. But in preparing for this interview, I learned some things that I hadn't known before. And one was, and maybe it's not accurate, I hasten to say, but I read that you first started teaching women and the law or women's equality when you were at Rutgers Law School because at the behest of female students who asked you to teach that course. Is that right? And can you tell us a little bit about it? What had you been doing before that?
I'd been teaching procedure in federal court, conflict of laws. There were two things that propelled me into the women's rights arena. One was the students, as you mentioned. They asked to have a course on women and the law.
Were those courses being taught at other law schools yet at that point?
NYU had a student-initiated course. In fact, I think the students at Rutgers were stimulated by the NYU students. And a few other places. Well, to teach this course, I repaired to the library, and in very short order, I'd read every federal decision that had to do with women's rights, or the lack thereof. And that was no mean feat. There was precious little. I think there was no more than what would be produced in 6 months these days.
Did the students approach you because you were one of the few female faculty members? Or?
Yes. There was one other woman on the faculty. She preceded me by a year. Then there was another thing, and it was the New Jersey affiliate of the ACLU, they began to get complaints of the kind they didn't have before. So who should help them with these cases? Well, why not the procedure teacher at Rutgers? Many of the complaints were from school teachers who were forced onto what was euphemistically called maternity leave as soon as that pregnancy began to show. Because after all, the children didn't think the teacher swallowed a watermelon. And these women, their view was, we are ready, willing, and able to do this job. There's no reason why we should have to go on unpaid so-called leave in the 4th month or the 5th month. And then there were some women, factory workers, whose employers had good health insurance programs. The women wanted health insurance to cover themselves and their families. The employer told them, you can have coverage for yourself, but family coverage is available only to men. Those new complaints coming into the ACLU. So it was a combination of the new complainants on the one hand, my students on the other.
And one would think that civil procedure doesn't necessarily lead to women's rights, and yet I've also read that it was your work on a project on Swedish civil procedure that led to your awareness of gender inequality or the power to do something about it. And if I can add one other thing, you have talked about when you were at Harvard Law School where you started your legal studies. I know Columbia is very proud to claim you as a graduate. I think Harvard probably claims you as an alum too. But
anyone who has attended one day is an alum.
touche. That you actually, there were so few women's restrooms that you even had to leave the building where you were taking an exam to go to another building.
There was only one.
Well, only one.
And that there's a wonderful book called Pinstripes and Pearls. It's about the class of 1965 at Harvard Law School, Justice Breyer's class. Mine was earlier, 1959. What was it going to cost Harvard to admit women for the very first time in 1950-51? What it was going to cost was the installation of a woman's bathroom. And there is later Dean Griswold's budget down to the penny, what it would cost to put into Austin Hall a women's bathroom. But there was just one. And in those days, there were 2 teaching buildings, Langdale and Austin. And if you were in Langdale, you had to make a mad dash to Austin. And that was particularly trying at exam time. But the thing that is remarkable to me today, the 9 women in my class and the 5 women in Marty's class, we never complained. We just thought that's the way it is.
And I'm struck by that, and I would love to know what changed, what made you think that you should complain and that complaining would get you somewhere. Can you pinpoint that or provide some background?
Because of the women's movement that came alive in the late 60s. Oh, we're going back to Sweden.
Yeah.
So, and I should say that one of the prime movers of the Columbia Project on international procedure is the great Judge Jack Weinstein. We were going through the U.S. Code and the federal rules to try to facilitate international cooperation and litigation. And part of the project was to study another system. So I was chosen for the Swedish book. There was a book on France, one on Italy and Sweden. I always suspected that the reason they came to me is knowledge of French law, knowledge of Italian law might have some commercial payoff. But Sweden, they have fewer people than the city that we are in. So I think they went down the list of women's graduates and then came to me. At any rate,
And I heard you actually learned Swedish for this project.
I had to read the Rättegångsbalk, that's their code of procedure. So I'm in Stockholm and I read a column in the daily newspaper. The topic is, why should the woman have 2 jobs and the man only 1? Sweden was ahead of the United States at that time, in the early 60s. It was well accepted that families ought to have 2 earners if they want to do well for their children. But the woman was expected to have dinner on the table at 7, to buy their children's new shoes, take them for their medical checkups. So this column, why should the woman have 2 jobs and the man only 1, was a subject of debate among Swedish families. Some women, the queen bee types, thought, I can do it all. I can do everything. I can maintain my medical practice and still make sure that the slippers are waiting for him when he comes home. Others said, none of that. He should do a lot more than take out the garbage. That was the tenor of the conversation. And I kind of put it on a back burner in 1962 and 63 because I didn't, our society was not yet ready to make that move. And then there was something else. I don't know if people in this audience are old enough to remember the name Sherry Finkbein. Mm-hmm. She was a woman who had been prescribed thalidomide by her doctor when she was pregnant. Mm-hmm. And she was at a very high risk of having if she carried the fetus to term, of having a child that would have multiple disabilities and not live very long. So she was from Arizona. Abortion wasn't available to her. She had heard that Sweden was a place with good health care facilities, and she could go there and have her abortion. And that struck me, that a woman from the United States traveled to Sweden to get a procedure that should have been available to her as part of her health care package.
I remember that case well, and well, we saw that Senator Helms said that you supported abortion. That, you know, we saw just a couple of weeks ago the anniversary of Roe versus Wade. It's still as contested as it was. You famously, at the time, were constructively critical of the court's analysis, suggesting that maybe a different rationale would have been a stronger one. Is that something that you feel free to comment on? Has your criticism been vindicated by what's happened in the many decades since?
This is a highly debatable topic. It was my view that it would have been better for the court to proceed the way Thurgood Marshall did. That is, many times he stood before courts and said, separate but equal is not before the court. Today, these facilities are vastly unequal. He worked up to Brown v. Board, and the building blocks were in place. Roe was the first time the Supreme Court had an abortion case. They had had a contraceptive case, Eisenstadt v. Baird, but
U.S. versus Vuitch, I think, in 1971. Looking at Kathleen.
that was a
Earlier
due
one.
process case.
Yeah,
Yes, that
yeah,
was
yeah,
Norman
yeah,
Dawson's
yeah,
case.
yeah.
At any case, my thought was that the court would work. It had an easy case before it. Texas had the most extreme law in the nation: no abortion unless necessary to save the woman's life. The court could have declared that most extreme law unconstitutional. There's something that a very distinguished constitutional law scholar, Paul Freund, said about Roe v. Wade. He said, it's like asking a grandmother is having a tea for her friends, and she trots out her little grandchild and asks her, do you know how to spell banana? And she says, well, yes, I do, but I don't know where to stop. that was Freud's comment. But my idea was that, so that would be the beginning, the first step. Then there'd be other cases. Among those other cases would be the Medicaid coverage of abortion. And it just happened in reverse. The Supreme Court decided Roe, and then a few years later, in 2 cases, it said no Medicaid coverage.
So you've touched on actually litigation strategy, although in fairness, I don't know what relief the plaintiffs in that case were asking for, whether they were overreaching in your view or whether the justices did. But it's an opportunity for me to put to you a question that many students were eager to hear you comment on, Justice Ginsburg, since we have a very active and successful moot court team here. They're very proud of their advocacy ability, but always looking to improve it. And obviously, you were a very successful advocate. And as a judge and a justice, I'm sure you've heard advocacy from the worst to the best. Can you give some pearls of wisdom for beginning fairly new advocates of how they can be more effectively, both in their oral and their written advocacy?
For oral advocacy, my advice would be remain flexible. You're there to answer the questions that are on the court's mind. If you come with a prepared spiel, you will be distracted. You don't need to lecture the court because they will have read the main lines of your argument in your brief. So use the time. Don't have a painful expression when you're asked a question. Welcome it and kind of ride with the wave. For brief writing and for opinion writing, my advice would be take the time to write it not only clear, but short. The lawyers tend to fill the space allotted. So no matter how many words we say, a brief can include, even in a single issue case, the lawyers will fill it up to the last page. Lawyers who do that are losing an opportunity to keep the court's attention. If you want to be sure that not only the law clerk, but the justice will read beyond the summary of argument, then keep it clear and concise.
Okay.
I think Bob mentioned read aloud. That's a good test of writing. If the sentence runs on and on, so you have to take a breath in between when you're reading it, rewrite it.
It's so interesting that you say take the time to make it short, because one of the questions I got from students was how much editing you do of your own opinions. How many drafts do they go through before you circulate them?
Many. And there are many drafts before I circulate to the court. And then there are more when I get back when I call Dear Ruth letters. Inside the court, we use only first names. And a Dear Ruth letter might say, I would like to join your opinion, if you will, take out footnote 5, put a citation to my opinion in the XYZ case. And in those, I followed the advice of Chief Justice Hughes, who said he always tried to write his opinion as clearly and concisely as possible. But if a colleague wanted him to put something in or take it out, well, in it goes or out it goes, and let the law schools figure out what it meant. So an opinion of a collegial court is an opinion of the court. So at conference, I will take notes on what my colleagues said and try to incorporate their views when we are on the same side. So I never write a majority opinion as though I were queen. I'm not. I'm writing for the court. Dissents are another thing. There you have a free hand to say what you please, without worrying about bringing along colleagues. Although sometimes when the court divides 5-4, you try mightily to change your 4 into the 5. And it happens, not often, but every now and then it does. I can't disclose the opinion, but there was one time my senior colleague assigned me a dissent in a criminal case. The vote at the conference was 7-2. In the fullness of time, after the court's opinion and the dissent was circulated, the opinion was released. It was 6-3, but the 2 had become 6. So it ain't over till it's over.
Yeah. Well, we started a little bit late, so I don't want to tax your graciousness by asking more questions, because I want to turn it over to the audience, and you should let me know. Do you have time for some audience questions? So I'll call on people in the order in which I see your hands go up.
Do we have a microphone for?
Oh, I'm so sorry. So please go, just stand at the microphone if you don't mind, or go to the microphone, and if somebody wants to go to that one, we can just alternate questions.
I love my wife, who's here, Diane Schroeder. Throughout our courtship and our marriage, I heard the following, that she created the first Women in the Law course in America at the University of Pennsylvania and NYU Law School, and that one day she received a phone call from a woman who was a law professor at Rutgers Law School saying, Diane, I understand you have a syllabus, and I'm to create the Woman in the Law course here at Rutgers. Do you think you can send that to me? Does this have any recollection in your mind,
Yes,
Justice
Diane.
Ginsburg?
So where is Diane?
She's right here.
Good to see you. But we met, you were at Columbia when we met, I think.
Yes, correct.
So do you remember that phone call?
Yes.
I remember Diane.
Hi. Your Honor, my name is Liz Holtzman, and of course I've taken great pride in your amazing accomplishments. I'd just like to ask you, and I think the students might appreciate the answer as well, what's it been like as more women have joined the court? What difference have women made on the Supreme Court? If you feel comfortable answering that.
But it makes a tremendous difference for the public coming to see the court. Sandra Day O'Connor was alone. She was a lone woman for 12 years. When I joined her, the bar was accustomed to there being a woman on the court. So invariably, at one sitting or the next, a lawyer would refer to me as
Justice O'Connor.
Justice O'Connor. And she would sometimes say, I'm Justice O'Connor. She's Justice Ginsburg. The worst time was when Justice O'Connor left. I think it was 2006. And I was all alone. So when the court takes the bench, you see these 8 rather well-fed men. And then there's this one very little woman. Now I am joined by Justice Sotomayor and Justice Kagan. I sit toward the middle because of my seniority. Justice Sotomayor is my left, Justice Kagan on my right. And anyone who has attended a court session will know that my newest female colleagues are not shrinking back. They take a very active part in the colloquy that goes on at oral argument. So it's great when the school children who come on a special line 10 minutes to watch the court, when they see that. So I think we are what they call a critical mass. When I'm asked, so when will there be enough? My answer is, it's evident when there are 9. And it's not you don't mean that, do you? There was nothing strange about 9 men for most of the court's existence.
Thank you. More audience questions? I can't believe what a shy audience we have. Can we get questions from the students who are downstairs or in an overflow room? Okay.
This is not a question because I have so many. I would like to present you with something, please. An assortment of vintage French lace collars for you to wear. With
Well,
Thank you.
well, you're giving me permission, as is the absence of audience questions, too. I had this list of topics in categories, and I thought I could be like a game show host and let you pick the category, but the one I was rooting for was fashion.
Can I tell you a fashion on the court? Well, a fashion maker, you'd think this is unlikely, but it was the old Chief Justice Rehnquist, who one day came into the conference room with a new robe that had 4 thin gold stripes on each sleeve. People were appalled. Is he trying to act like a master sergeant? And I couldn't contain my laughter because I knew just what he was doing. That summer in Washington, D.C., there was a production of the Gilbert and Sullivan operetta, Iolanthe.
Yeah.
There's a part in that for the Lord Chancellor. This was a company with a low budget. The Lord Chancellor that sits on the woolsack in Parliament has 4 gold stripes, but they're wide, they're brocade and glittering. The chief copied the summer opera company's costume with the thin gold stripes. And then when people asked him, well, why did you do that? He said, because I didn't want to be upstaged by the women. Because Justice O'Connor and I both wore, we had a variety of collars that we wore.
Well, so, are you the judge, or maybe you did it when you were a judge, I don't recall, or justice, who started the, what is now, it seems to be a pattern among female jurists of wearing collars? Or
I started wearing collars on the D.C. circuit, and it was the result of a gift from a woman who was then on the Supreme Court of Canada, Claire Louis-Dubé. And in Quebec, both the lawyers and the judges wear robes. And the men wore it's the traditional daumier jabot, the pleated. The women at the bar in Quebec decided we can do a little better than that. Let's put a fancy lace collar, add that to the jabot. So that gift started my collar collection, and now I have many from just about around the globe.
wow. Somebody, I read in one of the interviews that, and again, I don't know if this was accurate, that you have a dissent collar and a majority opinion collar?
Yes, the majority opinion collar was a gift from my law clerks, and it's gold and eye-catching. And the dissent collar is black with gray beads.
Well, seeing no, is there one more audience question and two? Okay, and then we'll call it a halt.
Thank you for your time, Justice Ginsburg. I just had a question. As a young lawyer, what are some of the successful traits you've seen in advocates on your many years as a bench, and what advice would you give to young lawyers who are looking to be more successful advocates?
The advice I would give mainly to young lawyers about their careers is don't settle for being a plumber. That is, you have a skill, you can get a day's pay for a day's work. If you regard yourself as a true professional, you will do something outside yourself. You will do something that makes life in your community, your country, a little better. So I would say pick whatever is your passion, whether it's the environment, whether it's equality, and work together with like-minded people. I've already given one piece of advice about oral advocacy. That is, it's not an occasion for speech making. It is a conversation between the lawyer and the judges. And if you can welcome rather than resent questions, the court will appreciate your argument.
Thank you very much.
And could you please tell us who you are when you ask a question?
Sure. I'm Josh Robin. I'm a reporter for New York One television station here. Welcome back home to New York. I've been reporting, a number of people around here have been reporting on corruption cases within the city and the state, and they have been overturned, a couple of them, because of the McDonald decision. Forgive me, I don't know if this breaks the Ginsburg rule, but I was wondering just generally if you can explain a little bit about the decision, considering it's being cited so much, and people are concerned certainly about corruption within New York and across the country. Thank you so much, Your Honor.
I didn't hear the opinion that you mentioned.
Can you tell us the name of the?
Oh,
it is a
the
past.
McDonald opinion.
Yeah.
The ex-Virginia governor. Thank you.
I can only say that every defendant, no matter how small or how large, is entitled to due process. And that's, if you read the McDonald opinion, you'll find that that is what motivated.
Okay, well, Justice Ginsburg, thank you so much for everything you're going to do for the next 20 years at least.